Yes, my name is James Clark. You have my oral argument of June 5th, 2013, under advisement that I had filed with the Supreme Court on my appeal in regards to the findings of facts and conclusions of law that was done by Mr. Donahue from the Industrial Commission, which I also have read some of the things that Lynn Luker has been doing during his office here in the last few months. And I noticed that there was a secret hearing in legislation in regarding to how complaints are handled that are filed through the Industrial Commission. I believe that was changed unanimously based upon my case that Lynn Luker was involved. Sometime in January is when they had this meeting behind closed doors. So, 40016-2012 is my Idaho Supreme Court docket. I'm going to go through a list. I put together a video that kind of outlines some of the lies that they had stated in their oral argument of June 5th, 2013. And I'm pleading this court, the Idaho Supreme Court, and the Supreme Court justices to overrule their findings of facts and conclusions of law, for they say that their evidence is based on substantial support. That's a lie. My very first video, 2013-624, outlines the Supreme Court CD that I received from the Idaho Supreme Court, free of charge based upon my financial hardship. And what I did is I put in the exact areas of where they lied. If you want to fast forward to the CDs, when they stated that I'd only been put back to work part-time for 2 hours a day, that's a straight out lie. I can produce a document, which I have, to show otherwise. And then Miss Rachel O'Barr straight out also lied to the Supreme Court when she stated that the law firm did not come into the case until after the fraud was committed by Mr. Julian by receiving my private health records on August 1st, 7th, and the 11th of 2008. Clearly, that was a lie. Is that all these people do, is lie and expect that they'll just get away with it? Because they did straight out lie to the Industrial Commission for 3 months. And it was because of Mr. Donahue not doing nothing about it and allowing him to get away with it. 2 years later, I had to contact an attorney, or I tried to hire an attorney, which is where Lynn Luker came in after I put something on a web page, on an attorney web page, on how the state insurance fund had committed fraud, and and how they lied to the Industrial Commission. So, and that was after 2 years of the living hell that they had put me through. And the video, also talks about other issues which they will not be able to produce, supposedly, because these doctors were paid, that they went with by the state insurance fund based upon documents and reports from their paid physicians of false statements to benefit the Idaho State Insurance Fund, which I would like for their doctors to produce their findings. So, that's what's in the first video. That's in the first section. Section 2 is it talks about my motion to the Supreme Court, my first motion that I had received from Mr. Steve Kenyon, clerk of the court, in relation to my February filings for stay of all proceedings, and also how later on you'll see one of a document showing that it was considered mute, but you know, based file for me, you know, so when I filed that first affidavit and everything of stay of all proceedings based upon my concerns, because I guess I didn't file it properly, but in the Idaho appellate rule shows that an appellant who is having to do it on his own doesn't have to be exactly on, but if it's there in the printings and it's understandable what I am asking, then that document should have been filed. And clearly, it does state what I am requesting is a stay of all proceedings. And because I didn't file it right, I received an email from Steve Kenyon, clerk of the court, an email stating that that filing is deemed mute because I guess they didn't receive the hard copies that were sent through the mail. So instead of doing another one, well, I'll get to that one in another video. But so, you know, that's that filing of 2013 in February should have been deemed mute because the state insurance fund did respond to it by accident, and I did receive their response to that motion, but then, you know, by accident. But that filing was supposed to be deemed mute, but was it? No, it was not. But my understanding it was, and by my filings. But the Idaho State Insurance Fund, through their attorney, Anderson Julian Hull, well, what I did is because they didn't receive my first documents to back up my reasoning for stay of all proceedings, and since I have some concerns about my alterations of documents anyway, and since that's deemed mute, well, I decided not to file the same identical one. So following that email, I went ahead and filed another motion for stay of all proceedings, and that stay of all proceedings had like 20 issues in it instead of only the 13 issues that were in the first filings of stay of all proceedings. Now, when the Idaho State Insurance Fund responded to my second one, they also spoke about the first one, which was deemed mute, which was nothing anymore because they said that under Title 44, Chapter 14, or whatever it was, that they kept sending those back, and that's the only issue, and blah, blah, blah. Well, this time what I did in my second filings is I sent 2 copies of the Idaho State Industrial Commission Rehabilitation Division's worksheets, which clearly show that both that Mr. Darrell Holloway's and Sandy Baskett's names were on the same dates with the same statements. Now, how could they, and this was And some of these documents were before Mr. Darrell took over from the vocational rehabilitation after Sandy Basket was removed because she wanted me to lie to an employer to get a job, and I wouldn't allow that. So I contacted the Industrial Commission, Miss Dina Burke, and then Miss Dina Burke directed me to her boss, which then her boss directed me to Mr. Donnie Uzna or something like that, and Darrell Holloway. They both met me over in Payette County Library. I mean, in Weiser Library for the first time in Weiser, Idaho. That's where we first met. And then Mr. Holloway started taking over. But then again, see, so his name shouldn't be on, like, say, way back in 5/24 of 2008. His should only be on, say, 8/9 of 2009 when he took over, or something like that. That's where the alterations of those documents come in, because they're trying to defend and back up Mr. Darrell Holloway no longer works for the Industrial Commission Rehabilitation Department, neither, as Miss Wilson / Arnold, clerk of the courts of the Industrial Commission, no longer works. So, these people happen to just disappear like a fart in the wind, so I can't ask questions, which I had a lot of concerns about Miss Wilson, because a lot of the documents that I received that were altered came across her desk, and that was in my second filing of all motion for stay of all proceedings, is because she should have been aware, or she should have taken the responsibility and notified somebody due to the alterations of these documents that clearly had to have crossed her desk to be mailed to me. So she had a responsibility to report these altered documents that were being sent to me, but she did not, which is in my which is in my motion for stay of all proceedings in the second one that I filed on the 27th of February of 2013. So go ahead and take a look at that one. I'd like to now go to number 3, section 3, which would be about my affidavit of stay filed February 17th, and also the respond letter that comes back with that. So that's where number 3 is. And then 4 and 5. 4 and 5 is the job, is my return to work. This is the job site evaluation that the appellant nor his boss received prior to me being returned back to work. I also have a copy that has Carol Garland's signature on it. So, not sure how I ended up with this copy. Probably because it was probably the first copy that I received. And then when they realized that I was catching on to something, during one of their filings back to me, the law firm must, or not, they must have slid that one in too to kind of confuse me. So when I did go to start looking at paperwork again, I'd be seeing that document, not thinking that there was another document. But then, it's complicated. So, that's, oh, excuse, wait a minute. Let's go to number 4. 3, 4. My bad. Number 4, actually, the number 4th one is this is the 4th would be mine and Elaine's first video that we put together, that we put out on eBay. I mean, not eBay, but on YouTube. And it also shows one of those altered documents. If you hold it up to the window, there at the close to the end, shortly before the end of the video, you'll see where I stuck it up to the window light, and you'll be able to see where I mean by some of that one. Now, my affidavit also, if we go back, my affidavit for stay of all proceedings was, I'll save that for a rainy day. Well, Number 4 is my first letter that I had received that I was being sent back to work. And that letter is from my boss on May 30th of 2008. Clearly shows that the Idaho State Insurance Fund and their attorneys lied again at oral argument, because this is my document to show that I was put back to work, not at 2 hours a day, part-time, as they stated there at oral argument on June 5th of 2013, but in fact it's the letter stating that I've been returned back to work full-time. 10 hours a day, 4 to 5 days a week. Now, and that was based upon the fraudulent job site evaluation that Carol Garland and Sandy Basket used to put me back to work, that started my first complaint against the Idaho State Insurance Fund, not against my claim of the injury, which that is a totally different number than my actual complaint, because my injury number is 2008-06268. And then if you have a complaint against the state insurance fund, you must file that separate. And that's what I did. And that is how I ended up with the number 03505. 013505 is my complaint against the state insurance fund, not against my claim. So again, what the hell is before the Idaho Supreme Court? So there's where we're at there. And 4 and 5, well, the next set is the job site evaluation that was supposedly put together by Sandy Basket. But clearly, she did not go out to the job site to do that evaluation. I have some kind of paperwork that kind of shows where there was a rough draft made. And then it even says in somebody's writing there that it was done over the phone on May 29th. So things aren't making sense there. And even if me and my boss even had that job site evaluation could not even have been performed. I mean, if you look at Miss Sandy Basket's notes, they're in June, April, May. Yeah, in June, you can clearly see where she tried to contact my boss to set up an appointment to come in and take a picture of the job site. Now, this was after I had refused to go back to work, because they put me right back to next to the machine that almost took my life, let alone I had to stand there for 10 hours a day, 4 to 5 days a week, on all this medication. My arm's still being bandaged every day due to the drainage because of the over swelling of my arm. But again, Miss Carol Garland, she just didn't see the magnitude of my arm. She thought I just crushed it. So, we'll play him off. We'll just push him off, send him on back to work. He ain't got nothing going on. So, even if both of us had that, we couldn't have been able to perform it, because there's no place that I could have put a chair right next to the place where I was put back to work. And that's when she set up the appointment with my boss to take pictures. Well, a few days later, she called and canceled that picture taken. But in the claimant's opinion, or appellant's opinion, is because if she would have taken the picture, then it would have been proven for a fact that in my filings that I was right, that they did put my life back in danger when they tried to put me back to work in the fraudulent manner that they did. And they did cause me more psychological damage by putting me back to work where they put me back to work. And then on top of it, that place wasn't even suitable for people to even be working at based upon OSHA's report. So that's what, that's basically about the job site evaluation. And then in number 7, letter to the court. About the next one is my letter to the courts, to the Supreme Court. I responded to something that I don't even think I should have responded to. And then when I did get a response, it didn't have no reference number or anything. But about the hearing, that they did, the video is going to talk about the hearing that they had on August 23rd of 2012. Now, again, this appellant was denied his due process, for they were trying to set me up with some hearing prior with only a couple of day notice. And because I knew that I couldn't make it because I'd already had previous appointments set up to where I wouldn't be in town and I would be out of town, and they were very aware of it. I told them to send me a copy because it's like they had already set it up without me even asking me. So I told them to send me something in the mail, and I'll let them know if I can make it on that date. Well, instead of mailing that, they sent me a hearing worksheet schedule. That way, both attorneys both parties can put a time, a date, and see if we can basically come together. And I had until August 23rd of 2012 to respond to that hearing worksheet. Now, I contacted the Idaho State Industrial Commission, like I always do before I come into town, that I'll be coming into town on the 23rd, which was the next day, to file my hearing worksheet, which was due on August 23rd. Now, what Miss Wilson / Arnold, who no longer works for the Industrial Commission as the agency for the agency's records, clerk of the agency's records, what she did is she turned around and they all set up a hearing stating that I approved it, which I didn't approve it for that time. If they wanted to set one up, I did for the afternoon. But they said that I did it for that morning at 10 o'clock. But they know I was coming in. So what they did is they went ahead and had that hearing when I still had until the 23rd to have the hearing worksheet, because there's a lot of stuff that they don't want published or knowledge, because I'm not supposed to make it this far. They've already stepped on their toes. Now, so again, I did file my hand-delivered, me and Elaine Kerr, who sat at the table to help me with my paperwork based upon my disability, which I received a letter from Steve Kenyon stating that, yes, Miss Elaine Kerr can sit at the table, but she cannot speak. But then when I get to oral argument, and after oral argument, I get to thinking about how Miss Rachel O'Barr was introduced and how Miss Elaine Kerr was introduced. Well, they were introduced both identically. Miss Rachel O'Barr spoke. So does that mean that Miss Elaine Kerr could have spoke? Because that's what I was wanting her to do, because she was with me when I drove a couple of times to Idaho to file documents, because she was there to help me file my documents based upon my disability, she would go there with me to help me file them, and she would be a witness to these filings. But for some reason, Steve Kenyon's sending me these emails that aren't making sense to this injured worker that has to do all this on his own. So again, I don't know what happened there. But I know that now Elaine Kerr could have spoke. So why did I receive that letter from Steve Kenyon, clerk of the court, stating that she cannot speak? So, again, I was denied my due process when they had that hearing August 23rd of 2012 in regards to the augmented records, and which me and Elaine Kerr was there August 23rd because I went and had it notarized at my bank there in Boise just before I went, and it was like about 2 o'clock in the afternoon or something like that. But I did ask them if they had that hearing, but instead of telling me yes or no, they called the cops and had me removed. Because all what I was doing was asking them, because I have that right, do I not? Do I not have the right to ask a question or go and investigate my claim? But clearly, you know, I get these threatening letters from the Industrial Commission, Mindy Montgomery, stating if I enter any building that the commission occupies, I will be arrested. Well, that will include all unemployment offices of the state of Idaho. And I believe the commission probably occupies the courthouse because of the judicial. So, you know, come on. That was just an intimidation, I believe, in my opinion, and I will find that out after I take it to and file a civil suit, in which I'm going to do, unless they're willing to still bring this to a close properly and not fraudulently. Now, in number 8 is a copy of page 6 of the OSHA report that clearly shows that it wasn't partly my fault that I was injured. Because when they responded to my complaint, they crossed a box that said that the accident was caused. Well, you have 2 boxes you can fill out, cross out. You can cross out the one that says the accident was caused entirely or partly. Well, they thought they'd go ahead and mark out the partly. Well, I didn't like that answer. And I'm trying to figure out, what do you mean partly? It was caused 100%. So I contacted OSHA. And so it was 100% their fault. Show anywhere where it was any of my fault. Anywhere. Mr. Donahue. So there's that one. And then you got the one in number 9 will be the filing of chapter 44, title 44, chapter 14 from Miss Wilson, which was being returned, which also other documents were being returned along with those. That's where it comes into Lynn Luker. Because some of the ones that were altered and sent back to me as non-filed is in regards to Lynn Luker's lien that I filed to the Idaho Supreme Court. Which I was told by Steve Kenyon in front of a police officer that day at oral argument on June 5th, 2013. Is there any filings or lien filed with the Supreme Court in regards to Lynn Luker? And Mr. Steve Kenyon, clerk of the court, said no. There is no filings in regards to Lynn Luker before the Idaho Supreme Court. But obviously, I'm being told there is now. So who do I believe? Because I have no orders from any, a lot of these filings that I've had to respond to do not have orders to them. where I've supposedly lost this or lost that. Nope, it's been ordered that you can't do this. I ordered. Well, where's the orders? Where are my mailed orders to notify me that that's been denied? Are facts. Number 10. That is my first knowledge that I was being returned back to work was the May 30th letter that I did not pick up from the post office until probably about the 6th or the 7th of June of 2008, because that's another one of their problems. They keep leaving out the year. You need to catch on to those years because that's very important. But I noticed that they always make sure that when it pinpoints to something that they can prove, it's the year, date, time, month, week, day, everything's right in order. Because a lot of this was prior to 2010 when I hired Lynn Luker. Matter of fact, 99.99% of everything is in relation to my filings prior to the hiring of Lynn Luker of the fraud committed by Ms. Julones of the Idaho State Insurance Fund on August 1st, 2nd, and 11th. August 1st, 7th, and the 11th of 2008 when receiving private health records and sending them to their doctors without my authorization. So, that job site evaluation was done or sent to Dr. Gross on May 29th. My referral was finally sent to Dr. Hansen's office on May 29th. So you see, they're not telling you everything. They're in the Supreme Court. They tried to make you believe that Dr. Gross signed off on this medical, and so I went ahead and just transferred my care over to Dr. Hansen on the 30th. But you see, I had an appointment with Dr. Hansen set up for 3 weeks in advance on the 30th. That's why I fought with Miss Carol Garland to get my referral that has to be sent to Dr. Hansen before I can be seen. And on May 29th is when they put together the fraudulent job site evaluation, faxed that over to Dr. Gross, had him sign off on it. It kind of took like all day to do, and then faxed it back, and then faxed Dr. Hansen the referral. Now, I can almost bet my life that Dr. Gross's was all done prior, because everything's got to be done by time-wise. Dr. Gross's was done prior to faxing over to Dr. Hansen my referral on May 29th also. So you see, because they finally contacted me on May 29th and told me we finally received the referral because I've been fighting for 5 days trying to get this shit done for them. So my appointment didn't get canceled because they refused to pay for my transportation to go all the way to Boise from Weiser and back. So I had to pay for it myself. I had to drive myself, even though that even at my hearing, some troubleshooter, somebody, the guy, he did give me a ride to Boise one time because I just couldn't drive, man. My arm hurt so bad I couldn't even touch nothing. And then in reality, the only reason I really went back to Dr. Gross on the 9th is because a letter that I received from the defendants stating that if Dr. Gross says that because it was my physical therapist that told me that I should write a letter to the state insurance fund because I almost started my house on fire the night before and my arm hurt so bad I couldn't even touch nothing. So I'm left-handed now, which is what I'm used to. And what I did is I fell asleep with that medication. So all what I was asking for was maybe somebody come and cook a couple of days a week and cook a couple of meals, so they'd last for a few days, about, maybe twice a week. So they can, cook my meals ahead of time so I don't have to worry about trying to make something. And I went. Just like when they stated in a filing that the Idaho State Insurance Fund has no objections to paying impairment rating by Dr. Hansen based on the 5th or 6th edition. So I went and I had it done. And then they withheld it from me and then had me file a stipulation knowing that it had been done. So they didn't have to pay me that they said that they had no objections to. The only reason why they held that, and my attorney withheld it for the whole year that he had it, because I didn't even go back to see Dr. Hansen again after that, after I had that second impairment rating. And since I did the second impairment rating prior to the hiring of Lynn Luker, and I was just waiting for the decisions and then for them to up my check, they did this, and now I know how that filing came in. They did, which I will show again in a civil suit. So that let's see here. So the 10 was my first acknowledgement, and then the 11 is the letter of fax to Dr. Gross on the same day as referral as sent to Dr. Hansen. And then number 12 kind of goes back to section 4. This is a picture of my arm when I was sent back to work full time, 10 hours a day, 4 to 5 days a week. So what really was I paid for on my time lost? Was it 4 days a week or 5 days a week at 10 hours a day? Because you see, we work 10 hours a day, 5 days a week, and sometimes 6. So, you tell me. Letter from the firm, number 13. Letter from the firm. This is the letter from the law firm of Anderson of Kagetcha Law Office in regards to where Mr. Roger Brown had worked. So, again, the commission as a whole allowed that statement to stay in the findings of facts and conclusions of law, when clearly I didn't fire no attorney. That statement was put in there for the sole purpose of Lynn Luker's lien, now that it's all been put together. Because I still don't know what Lynn Luker's lies were based on. So, why he quit, because I didn't even have the time to even argue it, because I guess he filed it one day, and by the time I found out about it, it was too late, because he was already granted 3 days later. Actually, 2 days later. Filed it on the 20th. 2 days later, on the 23rd, he was granted, but I wasn't aware that he was withdrawn until I received the letter saying that it was granted. So, was I not, again, denied due process to argue on why he feels he needs to quit, and I feel that he shouldn't have quit because we still had all them depositions that were still standing to be done that had to be discontinued, especially the ones that were ready to be done the next day before he quit. So, now, let's go to number 14. This is these are statements that were in Mr. Donahue's findings of facts and conclusions of the law, and the commission as a whole did their own findings of facts and conclusions of law. Again, in their findings of facts and conclusions of law, right there states in section 32, page 12, section 31 clearly states that Mr. Clark fired, I fired Mr. Roger Brown because I didn't like the way that he was handling my case. So I went pro se after that for a short time, which this is posted. I am seeking damages. And then if you go down to number 32 section, if you read the report, the appellant had concerns. Concerns. And if you go down to 33, clearly, and Dr. Holt said, also on page 12, section 32, Dr. Holt states that I was faking bad. Now, between August 1st of 2008 and October 10th of 2008, they were telling the Industrial Commission that without Mr. Clark signing these HIPAA medical release forms, that they can't get records from like the Idaho Department of Correction or any, I don't know. Well, I wasn't signing them because I hadn't gotten an attorney yet, but they didn't care. So, but in reality, they sent me to see Dr. Holt I went and seen Dr. Holt 2 days prior to Getcha Law Office removing themselves because Roger Brown no longer worked for their firm, is the real truth. Because I went and seen Dr. Holt based upon their doctors. I mean, it was one of their doctors, because I was told if I did not go to it, then I would lose benefits or, be denied or whatever. So I went to it. And now Dr. Holt was asking me something in regards to gout. Now, I've only been diagnosed with gout one time in a lifetime. And that one time in a lifetime happened to be while I was in prison. So when Dr. Holt started asking me about the gout, I go, where'd you get these records at? And also in his report, Dr. Holt, he does state that Mr. Clark asked him how he knew so much about him. And I stated to Mr. Clark that I received a tremendous amount of paperwork prior to my arrival. So I told him, well, I'm not going to answer any more questions because right now I'm fighting the Industrial Commission. I'm fighting the State Insurance Fund through the Industrial Commission that I don't believe that some of these records were relevant. But in fact, they had already gotten the same records that they're lying to the Industrial Commission, stating that they can't get. They already got them, didn't protect any of the information that were in any of these medical reports, and sent them to Dr. Holt, which is the same one that started the 5%. So that I only had 5%. That everybody really refers to, even in their oral argument that he state, or in their paperwork or whatever, they state where, Mr. Wilson, and then it says, and Mr. Holt concurs with it, goes along with it. But actually, it's really supposed to be the other way around, because Dr. Wilson went ahead and concurred with Dr. Holt, because Dr. Holt was the first doctor that I really seen of theirs. So there you are. So, Mr. Donahue and the commission as a whole, y'all lied, and I want this overturned. If it doesn't I'm still going to take you and sue you for civil damages and pain and suffering. State Insurance Fund for your lies okay, and then number 15, video 25. I thought I would ask Steve Kenyon, clerk of the court, about what's up in some of my financial, because I'm trying to get things filed, and I'm trying, and he's not being straight up with me. And but as you see at the end, I'm going, hello? He hung up on me because he didn't know how to respond anymore, because they're lying. Somebody's lying. Somebody's lying in the Supreme Court over that way. So, I speak about some things in there. It's interesting. And then 16, video 094, life flight report. It talks about the life flight report. And the life flight report, it states where where I was life flighted due to a pre-existing injury is another one of their misstatement in a medical report, if one exists, which I do have it. Because, well, they don't have it. They don't have a document from Life Flight that has that extra adding of the word to make that sentence sound different than what it really is. Because they have, they've got to match that box that they said that was caused partly, that would help the other part, which, I was life flighted due to a pre-existing injury, along with the blah, 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 and the pre-existing blank injury. They considered that and had to life flight me. So, but pre-existing, there is no such thing as pre-existing to life flight me, other than they thought they were going to amputate my arm because it was all crushed and just, yeah. So anyway, so let's, and then we'll go to the next one, 099. That would be number 17. 099. Now, I would like to know why, since, I hadn't filed anything, and I'm still getting the agency's records already, before Lynn Luker's lien was granted on July 10th of 2012, how can they already have in the agency's records Lynn Luker in the filings of facts and conclusions of law and order in the agency's records? There were 2 of them. I wasn't aware of that right off the bat because they had 1 findings of facts and conclusions of law in volume 7. And then they had another findings of fact and conclusions of law that was in volume 8. Now, I truly haven't really seen every single page that has been filed, but I was looking at one of the findings of facts and conclusions of law, and I was talking to Elaine Kerr in regards to it, and I'll be damned if she wasn't reading almost the same identical page. But then when we got to looking at it, because I thought it was out of the same findings of facts that was in volume 7, when actually there was 2 of them. There was one in volume 7 and then one in volume 8. The one in volume 8 has something in regards to Lynn Luker's lien. But then in your guys' reply brief, I guess I'm not entitled to attorney fees. I guess I could have been entitled to them if I could, because instead of, oh, here it is. Instead of Mr. Luker receiving the attorney lien for their denial, I should have been awarded attorney fees and costs because of their continued denial between April 17, 2008, up to the hiring of Lynn Luker of July 11th of 2010. Because they did continue to deny me my medication. I had to continue to argue it, and fight it, and then to fight these false filings that they were doing to the Industrial Commission for 3 months, well, longer than that, because I found out later on down the road. And then I was sanctioned for not signing medical release yet, and not to fully comply with their when they were asking me, because about where I've worked at in a lifetime. I had to get all this information, interrogatorial questions. But isn't that an ongoing The commission was demanding that I have it all finished. Everything that they wanted done by a certain date. But now, in theirs, we'll update when we know more. Now, I turned around and did the same thing. Well, because I tried to do my best because I couldn't answer them all. We'll contact you when I can. And in some of the areas I did fill it in. But I get sanctioned for it. And I did. In the findings of facts, I got sanctioned $300 for it. What did the state insurance fund get sanctioned? For their fraud. Well, I'll find that out when I take it to a civil action. Or file some kind of action, which will happen. I'm just waiting for the opinion of the Supreme Court. Because if they still don't want to bring it to an end, then I will turn around because I will, this is my life. And then when they did a reply brief to the Supreme Court, the state insurance fund, through their attorneys, or their attorneys that wrote it out probably, they sent me 2 briefs. 2 respond briefs. And it wasn't until a couple of days later that it dawned on me during my sleep, and it woke me up, that there was 2 findings of facts and conclusions of law, and there were 2 briefs. So I wasn't supposed to know, but I'm being told there's nothing before the Supreme Court in regards to Lynn Luker by Steve Kenyon, the clerk of the court, which would know what was filed. And I asked him several times, but all what he would tell me and respond to is, it's what you filed. Well, what I filed, well, I don't know what's before the Supreme Court anymore, because when you file a complaint, and that's probably why you changed the way in that little secret meeting, Mr. Luker, in the Industrial Commission, on how complaints are handled that are filed to the Idaho State Industrial Commission. Isn't it because of my case? Because, Lynn Luker, I'm going to ask you those questions when I come to see you during your re-election. Okay, let's go to video 101. The subpoena of Sandy Basket. I was granted a subpoena of Sandy Basket. It was an order by the Industrial Commission. Lynn Luker knew about it when I hired him. And his little smart comment was, oh, they don't do things like that. Because I told him I want Sandy Basket, subpoenaed. I want him to be calling her. And I go, oh, yes, they do, because I want it. And that was, a couple months into him taking my case, and he's not really doing much, so I'm kind of starting to get on his butt a little bit. And because he's not contacting nobody. Not one single person. I mean, not one single person did Mr. Lynn Luker call on behalf of me. He didn't call Ken Adams to talk to him in regards to their statements that I quit my job, which is stated and published that I quit my job and I walked off it. Again, misspoken, then it needs to be taken down because it's a false statement. Because I didn't really quit my work. Because I was forced back to work. Forced. Based upon a fraudulent job site evaluation that Sandy Basket, who worked for the Idaho State Industrial Commission Rehabilitation Department. Now, why would they even put me through there if they didn't even feel that I was going to be totally disabled? Well, that's because Lynn Luker came in to try to help cover up the fraud by the state insurance fund, and then to help cover up the abuse of authority that was done by Mr. Donahue, who is also just an attorney that was assigned as a referee to the commission. And then if we go to 102, clearly, in the filings again, in the same order with Sandy Basket, it stated that Miss Julones will testify. An opinion for Miss Julones is not necessary. Miss Julones will testify when a hearing is set in the future. Yes. But then again, in November of 2010, they filed the same identical motion. Now they're saying that I'm the one that was doing it. Nah. The state insurance fund and Miss Rachel O'Barr, who also lied in her affidavit in support of motion to have Miss Julones testify via phone, that they lost in 2009 when I was representing myself. But they turned around because I was telling Lynn Luker, no, you're gonna have her. She's subpoenaed. I want her to testify. Well, later on in November, from what I read after I get the reports, that they had a hearing, because I was wondering why she wasn't at the hearing. I was pissed off with my attorney, because if that wasn't really my hearing and it was on my complaint, then I can understand. But if it was for also my hearing for what I'm entitled to, see what they did is Miss Rachel O'Barr in the law firm filed the same identical filing that they lost with in 2009. They filed it also in 2010 November when I had with Mr. Lynn Luker, and then she was granted to testify via telephone. Because how I'm not understanding now, because I wasn't notified. Because I wouldn't have went for it. Okay, Lynn Luker. And then 108. Let's see here. A letter. And everything is the medical release. It should not. I had filed the document that you're going to see here is a filing I did to the Industrial Commission, because in one of the medical release forms it states that I should not be denied medical benefits, treatment, and other issues for not signing this medical release form. But isn't that a fact what I was being? I was being forced to sign that. And if I wasn't, then my claim would be dismissed, or my complaint. And isn't it a fact, Mr. Donahue, that I did file a motion? I did file something with you all stating that is it my complaint or is it my claim that's going to be dismissed if I don't sign these medical release forms? Because it does make a major impact on how I respond. Isn't that written to you all in a filing? Because you guys were trying to confuse me again, claim or complaint. And now that I'm even right here, that is kind of making sense. Because isn't my claim before the Supreme Court? Is it my complaint? Which nobody will really be straight out honest with me because of the corruption. And then Lynn Luker. Oh man. I'll just let you hear that one. And then the letter from, and then in the last CD, what you have is it's going to start off on something else, but give it about 15 seconds and it'll cut over into the one I did. Now, this is a letter because in the appellate rules, in the Idaho appellate rules, it also states that if somebody anybody can appear at oral argument, or anyone can write a letter to the Supreme Court that has an impact on the outcome of this case. Now, my mother has a interest on the outcome of this claim because it was a contract that I filed with Miss Jewel Owen and Miss Rachel O'Barr through the law firm of Anderson Julian Hull. It wasn't part of the transportation issues that I truly still got screwed out of, and you all still owe me a bunch of money on some of my transportation because you kept shorting me. And even Lynn Luker wrote you a letter in regards to it. And in one of my days that I spent over there all day, you still ain't paid me for that Lynn Luker talks about. Am I going to get any of that too? I will when it comes to a civil action, because I have my documents to back it up. All you guys are hoping for is the corruption that's going on in your local governments. Let's try to back it around here. Let's try to do this. That's the same reason why Lynn Luker sat in on that behind closed door meeting with the Industrial Commission on how complaints are filed with the Industrial Commission. Because when you file a complaint, I mean, I'm not sure what passed unanimously, but if it had anything to do, like I've been saying, it don't make a lot of sense for you file before the Idaho Supreme Court complaints about how the Industrial Commission handled your case in your hearing. Now, Mr. Donahue should have clearly stepped down, as the respondents or the defendants or whoever, the law firm of Anderson Julian Hull stated, or the commission or as a whole stated, that Mr. Donahue should have clearly stepped down due to his conflict of interest because of my filing to him directly, how he was allowing the state insurance fund to get away with it, and that I am asking for this to be forwarded to the Idaho Supreme Court, for I feel I will not get a fair hearing before the Industrial Commission. Now, didn't I file that also prior to Lynn Luker? But and somewhere I read it in the Idaho Supreme Court filings that if a person is to file an appeal before the Supreme Court prematurely, then that is to be filed following. Did that happen, Mr. Donahue? No, it did not. So, yeah, it was a letter from my mom that I had mailed to the Supreme Court that the state insurance fund denied to pay her based upon a contract. Not once, but twice. And since the injured worker had to pay his family, that is a bill that's outstanding. And because of your lies to try to cover it up, I am seeking damages on that. I want interest on it and penalties added onto that. So that's what I have going on. I have a lot on the line with the Idaho Supreme Court and you, Supreme Court justices, because this is my life that they have defamed, defamatory comments, lies that are posted for public view, statements that are put in medical reports that can no longer be taken back that are lies, false statements made by false statements or untruth statements, altered documents to make one look other than what it should appear, false filings. And Lynn Luker, you also did too. All parties involved. And it sounds like it's the state of Idaho. I have the Idaho State Insurance Fund, who committed the fraud. And then you have the Idaho State Industrial Commission, who has full authority over the handling of the Industrial Commission and injured workers, which that shouldn't be it. And then you have Lynn Luker, who comes in to help cover up the abuse of authority made by Mr. Donahue, referee, and the fraud that was committed by the State Insurance Fund that the State Industrial Commission was helping try to cover up and to try to sanction me $300, or it did happen, to sanction me $300 that I'm seeking back for refusal of signing medical records when I hadn't even got an attorney yet, and I'm still working on it. Because when I went to see their doctor, Dr. Holt, I just lost that attorney. Because I was on my way to their office to let them know what I just found out. When I talked to him on the phone, driving to Boise to the law firm. Well, sorry, Mr. Brown no longer is going to be working with our firm, so I had to flip a U and go back home and figure something else out. Had to work on another attorney, I guess. And that's where Lynn Luker comes in. I don't know if you're going to receive these videos, but, this is my video to explain to you that this is my life. I want to move forward. I understand that Lynn Luker is running for re-election next year. And if I would have known that in November of 2012 that he was also running for re-election, I would have been there too. But since I got a little heads up because I started looking into the background of Lynn Luker, and here comes a pop-up at webpage that says re-elect Lynn Luker. Oh man. And he wants to say, and he's using the old common sense. He uses this phrase of common sense. Well, wouldn't it have been common sense, Mr. Luker, to not have quit based upon lies, but in fact, you should have helped me win my case. And wouldn't it have been common sense not to also quit on my Social Security just a few months earlier? But you stated I didn't owe you anything for that. Well, why not? Oh, because you say you didn't file anything in regards to my Social Security. Lynn Luker, you are a liar. You use your office for financial gain. And since you were awarded that almost $4,000 in 2012, you must have needed some contribution money, didn't you? I'm going to ask about that too, Mr. Lynn Luker, when I come over that way to help you get reelected. See, Mr. Luker, I may end up with a bullet in me for trying to stand up for what I feel is right. But you know what? At least I know I was fighting for justice. I was fighting for my rights. My rights to know what you spent. Since I still never did receive anything that I was requesting during my argument in regards to your lien in May of 2012. Or July, all the way through July of 2012. So, you see, Mr. Lynn Luker, you refused to send me any receipts. You refused to send me a copy of the original signature of some contract you're saying that I signed with you. But now that I put it together and putting the dates together, your lien was on the 27th of December. So what you all did is you came back after based upon your lies to withdraw. You came back on the 27th, then quit again on the 29th, but you filed your lien on the 27th. Now, was that lien for the 3 days that you worked for me? Or was it for the time that you actually quit, but you didn't really file a lien? Because it took you guys over a year to truly respond to the briefs in regards to the hearing, when it should have only taken like maybe 3 or 4 months at the most. But because I lived over there and you guys are trying to figure out what to do, because you can't let all this out, because then it'll hurt how the Industrial Commission handles workers' compensation. Because it's a scam is what it is. It's a scam. Mr. Lynn Luker. Was I nervous in the Idaho Supreme Court talking? You bet. But because I sat down within a few minutes of speaking, and then to have them get up there and say what they said, and I just happened to have some of those documents to prove they lied sitting right there with me. Because isn't it really about the records, as they stated in their response brief to the Supreme Court, about the records that was presented at the hearing, that I didn't even hear what the records were being presented? Because again, Mr. Luker, you knew what was being presented in those documents. Even though they're saying that they're giving them right now without anybody being able to review them, Mr. Lynn Luker, that was a lie. You damn well know it. You damn well know that you knew exactly what was inside those documents that was being filed, but I didn't. Because again, in the Idaho Supreme Court, when I asked about the records, if something that says deemed mute means that they can no longer be used, and a couple of heads shook yes, then what the hell are you using them for? Because isn't it a fact that I've also got documents stating how you had returned all documents, scanned or otherwise, and we have no more records on our computers or in our system or on our property that has anything to do with the Idaho State, with the Idaho with Safe Corporation out of Ontario, with Safe Corporation out of Salem, Oregon. And those were the ones that Mr. Luker got filed. You little dirty shithead. Everybody wonder why I have a little anger? I have a right to be angry. So, I don't know. I hope this gets to the Supreme Court justices, because they did lie. I don't know what Steve Kenyon's up to or who he's really working for. But when I get something from the Supreme Court and I file with it, and it specifically says no reference number on it, and me and again, Elaine Kerr drives to Idaho to file some documents based upon that. And then when we drive 400 miles back, some of those documents disappear like a fart in the wind. But then I turn around and I write a letter to you, Justice, Sir Burdick. And I sent you a copy of the letter from the law firm of the Get Your Law office, showing that I didn't fire no attorney. Even though I was only allowed one response or something like that. That's where, and then some of these letters that I'm receiving from Steve Kenyon, clerk of the court, instead of when you go to copy it, how, and you run it all and you scroll it down and it all kind of comes out real nice. Some of my documents come out and almost like they were pasted in there. Like 3 or 4 words pasted, and then a break, and then 1 word break, and then 2 words maybe break, 5 words break. It's almost like they were pasted together. And then some of the documents that I scanned to my computer sure don't look like the letter that I'm scanning. But I'm being told it's probably my software. But you know what? I've been through 4 computers. And it does it on all of them. Steve Kenyon, clerk of the court. I believe that he, I don't know. The state insurance fund committed wire fraud by receiving my records also. That's wire fraud, man. They committed fraud when they received them by wire because they were sent over wire to them. Computer to computer, wire fraud. So, that's where I'm at, and I'm seeking the damages. And all what I'm asking for is the $1.2 million that is in my brief. Otherwise, I will be seeking damages and suing the state of Idaho. Because to me, the Idaho State Insurance Fund, the Idaho State Industrial Commission, and the Idaho State Legislator, Lynn Luker. And I have questions in regards to some of my filings with Steve Kenyon, clerk of the court, and some of my audio phone conversations with Steve Kenyon, clerk of the court, and also my audio version of the law firm, Anderson Julian Hull, Miss Rachel O'Barr, when it, they're back to back. But if you look on YouTube, you'll see them. One's to Steve Kenyon, clerk of the court, but he didn't answer the phone. So I went ahead and left it running and went ahead and contacted Miss Miss Rachel O'Barr. And that was longer than the one to Steve Kenyon. Then I called Steve Kenyon seconds later, and I do get through with him this time. But boy, in regards to the filing of my motion for stay of all proceedings, check it out. Again, the findings of facts and conclusions of law and the fairness of justice needs to be overruled. Allow me to move forward for civil action, or send it back to the Industrial Commission to have the right thing done. Because I could file it right now, a civil suit, but I want to wait for the the Supreme Court's opinion. I'm a little worried, but I don't know. So I'm waiting for your all's opinion. It's under advisement. So when Steve Kenyon says that I've talked to this justice, but then I went ahead and talked to another justice in some of these filings that keep coming back that I'm not getting orders from, they're just little emails, or is the state insurance fund accidentally pretending like they faxed me the wrong, faxed a document to me. Oh, I'm sorry. It was inadvertently sent to your address when it should have been sent to blah, blah, blah. But it was in one of my motions that I was supposedly denied. But I started asking questions about some of these ones that I was getting because they weren't looking right. So did I contact Steve Kenyon's boss? Somebody. I can't think of her name. But anyway, so please, sirs, Supreme Court justices, I'm only asking to have the right thing done in the fairness of justice. I'd just like to move on with my life. That's all I want to do, man. I won't have a life until they're out of my life. Until they're out of my life, I won't have a life. I just won't. I'm afraid I might lose this relationship too. Yeah. So, I don't want that. Thank you very much for your time. Truly. The law firm should bring to the Supreme Court to back up their statements of lies, or to show that my documents are fraud documents and they're not supported by substantial evidence, that I know that clearly theirs aren't, because I want their doctors to produce their reports that they sent to supposedly the state insurance fund, because isn't that whose reports they're taking it from, or their doctors? Bring those documents forward, their statements that they're stating that other doctors have said, because what they've done is they've tweaked them around, the true statements. They've taken true statements to sound false. Thank you for your time. This is James Clark, 40016-2012, begging the Idaho Supreme Court to have the law firm of Anderson Julian Hull come before the Supreme Court and back up their lies that they stated to the Supreme Court on June 5th at oral argument of 2013. Thank you very much.